What are the most overlooked steps in an Illinois estate plan? Many people believe their estate plan is complete once they sign a will or trust, but Illinois families often discover too late that critical steps were missed. An estate plan that looks solid on paper can fail in practice when assets were never transferred, beneficiary forms were left outdated, or healthcare documents were never finalized. These gaps frequently surface during probate, when fixing them is no longer possible and families face unnecessary delays, expenses, and stress. Under Illinois law, estate planning involves far more than drafting documents. The Illinois Probate Act establishes specific requirements for administering an estate, and missing even one step can delay distributions and increase court involvement. Chicago's Probate Division handles thousands of cases each year where families assumed a plan was complete, only to learn that trusts owned nothing, beneficiary designations conflicted with the plan, or essential records were missing. These outcomes are preventable with careful follow-through and regular updates. One of the most commonly overlooked steps is funding a revocable living trust. A trust avoids probate only if it actually owns the assets it is meant to control. Funding a trust means retitling real estate, bank accounts, and investment accounts into the trust's name. Real estate requires a new deed recorded with the county, while financial accounts require updated ownership or beneficiary paperwork. When this step is skipped, the trust exists in name only, and the assets still pass through probate despite the time and money spent creating the trust. Beneficiary designations are another frequent source of problems. Life insurance policies, retirement accounts, and certain bank accounts pass directly to the named beneficiary, regardless of what a will or trust says. These designations must be reviewed after major life changes such as marriage, divorce, or the birth of a child. Illinois law automatically revokes some provisions for former spouses after divorce, but it does not update beneficiary forms. Failing to update them can result in assets passing to unintended people and can override the rest of the estate plan entirely. Healthcare planning is also commonly incomplete. Illinois requires two separate documents to fully address medical decision-making. A healthcare power of attorney names the person who can make medical decisions if you cannot communicate. A healthcare directive, often called a living will, states your wishes regarding end-of-life care. These documents serve different purposes, and having only one leaves important gaps during medical emergencies. Hospitals rely on these documents to determine who has authority and what treatment decisions align with your wishes. Digital assets are another area many plans ignore. Online banking, email accounts, cloud storage, social media, and cryptocurrency often hold financial or personal value, yet access to information is rarely documented. Illinois law recognizes digital assets as property, but service providers frequently restrict access without clear legal authority. Without an inventory identifying accounts and access methods, these assets can be lost entirely. Keeping this information separate from a will is essential, since wills become public records during probate. Illinois estate tax planning is also frequently overlooked. Illinois imposes an estate tax on estates exceeding $4 million, a much lower threshold than the federal exemption. The state exemption is not portable between spouses, which means married couples cannot combine exemptions without proper planning. Strategies such as lifetime gifting, credit shelter trusts, and charitable bequests can reduce or eliminate Illinois estate tax exposure, but only if addressed in advance. Planning for disabled beneficiaries is another critical step. Leaving assets outright to a disabled loved one can jeopardize eligibility for SSI, Medicaid, and other benefits. Special needs trusts allow families to provide support without disrupting essential assistance, but these trusts must be structured and administered carefully under Illinois law. Finally, many plans fail because families lack organized proof that steps were completed. Executors and trustees need clear records showing that deeds were recorded, accounts retitled, beneficiaries updated, and documents signed. Without this proof, families spend months piecing together information during an already difficult time. Working with a lawyer or attorney who understands these overlooked details can help ensure that an estate plan actually functions as intended. A complete plan requires ongoing attention, not a one-time signing appointment. An attorney and lawyer at a law firm can help families identify gaps, update records, and maintain organized documentation. Choosing a law firm that focuses on follow-through can spare loved ones from unnecessary court involvement and confusion. Illinois estate law assists families with every step of the estate planning process, from trust funding to healthcare documents and record organization. The team at Illinois Estate Law understands how overwhelming these details can feel and works to make the process clear and manageable. If you have questions about whether your plan is truly complete, Illinois Estate Law is located at 4422 North Ravenswood Avenue, Suite 212, Chicago, Illinois, 60640, United States, and can be reached at 312-373-0731. Their guidance helps families move forward with confidence, knowing their plan is ready when it matters most.